we all welcome our third participant to the stage, Cherisse Francis. Cherisse is from Barbados and she will be speaking on the topic, should the state intervene to protect victims of domestic violence when the complainant fails or refuses to press charges?
I got flowers today. It wasn't my birthday or any other special day, but we had our first argument last night. He said a lot of cruel things to me, but I know he didn't mean them because I got flowers today. I got flowers today. Today was a very special day. It was the day of my funeral. If I had gotten the courage and strength to leave him, I would not have gotten flowers today. This excerpt from an anonymously written poem dedicated to the victims of domestic violence worldwide has become more the tragic reality of many, the unprotected victims. Therefore, in response to my topic, I posit that yes, the state should intervene to protect victims of domestic violence where the complainant fails or refuses to press charges. Regional legislation is largely ineffective for defining domestic violence. However, the Innocenta Digest, Volume 16, by UNICEF, in alignment with Trinidad and Tobago's legislation, defines it as violence perpetrated by intimate partners or other family members manifested sexually, physically, emotionally, psychologically, and economically. Traditionally, domestic violence is seen as a private family matter, not open for external interference. However, today, we accept that domestic violence is a public issue with state concerns that can be grounded in human rights. Thus, state intervention can be justified on two bases. Firstly, victims often emerging from the vulnerable groups in society, such as women and children, do not have adequate resources or power to protect themselves. Because of fear, reliance on the perpetrators, or existing emotional ties, they refuse to or choose to drop charges against their aggressors. Caribbean legislation, such as the outdated Domestic Violence Protection Order Act of Barbados, Section 14, still treats domestic violence as a private issue, requiring the victim to press charges and seek protection. This statute restricts the intervention powers of police officers to situations where they believe on reasonable grounds or invitation that physical suffering has occurred or is imminent, or where a protection order has already been breached. Often, by this point, a victim is too battered, physically or psychologically, to take measures against her aggressor. An officer's only course of action then is to file a useless complaint for records or to proceed under another statute. Implementation of policies by the state, which expand police powers and criminalize domestic violence, requires mandatory reporting of suspected domestic violence cases by medical professionals, and prevents the dropping of charges solely on the request of victims, as questioned by senior counsel Douglas Mendez in a recent Guardian newspaper article, would be more effective in combating the scourge of domestic violence. Secondly, international obligations, through countless treaties to which our states have become parties, require that states control human rights violations, including domestic violence. Two examples are the Convention of All Forms of Elimination of Discrimination Against Women, which provides that state parties must refrain from engaging in or encouraging acts of violence and must intervene in and exercise due diligence in preventing such acts, and Article 5 of the Universal Declaration of Human Rights, now customary international law, which provides a right to be free from all forms of violence. The importance of state intervention to protect a victim clearly extends beyond the domestic realm. State intervention is in no way 100% domestic violence prosecution guarantee, and both sides of the spectrum must be considered. Revisiting mandatory reporting, former magistrate from Barbados and human rights advocate Faith Marshall Harris, in a 2014 Barbados Today newspaper article, suggests that a policy requiring all patients whose complaints are inconsistent with their clinical presentation to be evaluated for domestic violence, and requiring all medical professionals to report such cases could be helpful in establishing a legal case and shifting the burden of proof from the victim. However, there could also be negative effects. Some concerns raised by the opponents of state intervention include breach of doctor-patient confidentiality, imposing stigma on victims and perpetrators, encroachment of the freedom of choice of victims in choosing how judicial courses against them will proceed, and making an already explosive situation even more explosive. The issues have been considered, but ultimately, the right to life and the right to enjoy your human rights without encroaching on those of others must far exceed concerns of anonymity and stigmatization. Therefore, state intervention providing proactive measures is a necessity. As we culminate 16 days of activism against gender-based violence today, ask yourselves, how many more victims will we allow to get flowers tomorrow before we intervene? I thank you.